Well, hello there. Thanks for joining me. I am Dr. Jen, and this is my life as a landlord. Today, we are exploring the location-specific tenancy guidelines for the great state of Maryland, home of the Inner Harbor, Baltimore, Blue Crab, all of the above. This is where I was born. This is where I went to school. I still have family there. And so I am actually really excited to dive into this. If you've watched the show before, you're going to know that in all of my location specific episodes, I've included tons of hyperlinks to resources to that location. And for Baltimore, I've got one, two, three, looks like 8 hyperlinks so far. And if we find stuff along the way, I will add it as we go. So check out the show notes. Also, if you'd like to, you can watch this on YouTube at My Life as a Landlord and check out the as I screen share. You're going to see me go through each one of these. Okay, each one of my location-specific podcasts is set up in the exact same way, answering the same 4 questions. What are the basics of the tenancy law in that location? What are the nuances in that location? What's missing? What's weird? One-offs, you'll see me as we go through this. And then what about guidance about abandoned items left behind by a tenant in Maryland? And last but not least, if you need help, where do you get help in your local area? And there's all kinds of resources. We'll get you started. And as I answer these questions, you'll see me screen share, as I mentioned, all kinds of documents. You'll see me check off items on the bingo card of what location has. Of course, as I've traveled and I've studied landlording around the world, I have created this bingo card of standard items I see most often in tenancies in different locations worldwide. And then at the very end of the episode, I'll go through that bingo card to help you figure out what you need to research more, especially if you are a landlord in Maryland in this case. But I must tell you that there may be more guiding documents than what I'm giving you here. Even if I get it 100% right at the time of recording, 5 minutes later, things can and will change. So you have got to do your own due diligence. You've got to ask questions specific to your rentals, to your locations, and to your situation, right? So while this episode may not be all inclusive, even though I try really hard to make it so, you've got to do your own research for your specific situation. There you go. There's your disclaimer. Okay, I am going to screen share here. How am I going to do this? Here we go. So I am screen sharing this side here. This is maryland.gov. Again, if you're at YouTube at My Life as a Landlord, you're seeing me share screen. And here's what we've got. Department of Housing and Community Development. This is Tenant and Landlord Affairs. And a little insight on what they do. Most resources, we're going to go through the Tenants Bill of Rights as well, renters resources, find support. Again, most of the resources you're going to find, especially as a landlord, that most stuff publicly is for tenant protection, right? It's not for the landlord. However, you can reach out as a landlord and say, I don't understand how this goes. And we'll go from there. So there's all kinds of contact information here, training request form. Let's see, that looks like Tenant Bill of Rights, first right of refusal. Yeah, they want somebody to speak to your group. Okay, tenant issues if you're a tenant and you need to report a violation. There's the email, professional assistance. If you're a housing industry professional, need technical assistant or need help with the Tenant Bill of Rights. So you can email them, and that's great. I mean, and I encourage you to do that. I ask tons of questions all the time of my rentals. You've just got to do it. And then general questions, customer service inquiry form. And I'm just scrolling down to the very bottom of these pages, affordable rental housing news. And I just wanted to see if they had any more contact information other than that. Looks like they're on social media. Yeah, there you go. YouTube. Perfect. Okay, so let's go up and take a look. So right of first refusal portal. I don't really understand what this is yet, but we're going to get into it. Tenants right of first refusal. Property owner. Okay. Property owners on all data entry forms. Okay, I'm not really sure what this is yet, but let's keep going. Renters resources. I'm gonna make sure that I'm human. Yes, I am very human. Find affordable housing, HUD resource locator, new leasing opportunities, properties under construction, Maryland Renters Tax Credit, financial assistance programs, housing voucher for veterans, yay, Maryland Department of Veterans and Military Family. and individuals with disabilities. It's actually really cool that they have all this. Folks who are elderly, facing an eviction or homelessness. Maryland 211. There's actually one here in Hawaii, the same thing, 211. Domestic violence, sexual assault, all these programs. Court Help provides resources for tenants and landlords navigating an eviction. In fact, well, let's just open this up. We haven't even gotten into the tenancy stuff yet, but that's okay. So tenants may qualify for a free lawyer. Notice they didn't say that landlords might, but you never know. So there's a bunch of, it's a free online classes. Here we go. Court help videos. Make sure you are watching these, especially if you're either new to landlording or you are in a pickle and you need some guidance. So educate yourself. And it will talk about what kind of case this is, what's going on. Of course, this is all tenant centric as if you're the tenant. And what happens in court? Security deposit talks about getting security deposit back. So this is like down the road. This is way more operational than, oh, it talks about foreclosure. What happens is with foreclosure if your home has been foreclosed on. Okay. All right. Let's go back because we haven't even really gotten into any of this yet. Tenant and landlord affairs. Oh wait, I think that was the first one that we did. Yes. All right, let's go to the Tenant's Bill of Rights, which is the second hyperlink in the show notes. Now, I will tell you, I have interviewed quite a few folks from Maryland, and I can tell you that each municipality, each county has their own rules. Sometimes you have to be licensed, sometimes you have to declare the unit. You've got to really make sure you understand what is going on in your local area. So it even says local rental laws and ordinances. Some county, city, township governments established rental unit licensing requirements or additional renter protections at the local level. And you've got to make sure you're doing that. Okay, so printable versions and multiple resources. Let's just go ahead and open this link. Okay, so Maryland Tenant Bill of Rights. This is 14 pages. And effective of about 6 months ago, October 2025. Okay, well, let's get into this because some of it has in here. This is actually great. Rental applications. Landlords who rent 5 or more units can only keep a maximum of $25 for an application fee unless their actual application costs, such as credit checks, are more than $25. And right now, if you're a landlord, you very likely know that credit checks or criminal record checks or any of that stuff, they are running more than $25. If a landlord charges more than 25 bucks, but their costs were less than that, they must refund the portion of the application fee. Must be made within 15 days of one of the following. Either the tenant's moved in or the landlord or the applicant gives written notice that the applicant will not rent the unit. Applicants may ask the landlord for a list of application expenses, which is reasonable. The list must include monetary amounts and descriptions of each expense. In fact, if I get asked, especially on the US side, I usually actually let the tenant pay for like the credit check. I don't actually charge a fee. I ask them to pay it. And so there's a couple different ways you can do it, but if you're going to ask for a fee, I usually send the receipt of what I paid for so that they're realizing I'm not trying to pay for anything else. Tenant screening report. Some landlords may choose to accept tenant screening report that was prepared by consumer reporting agency within 30 days before the application. If the landlord accepts such a report, they may not charge you an application fee. In fact, when I screen tenants, I will specifically ask them, do you have a credit report and score, both, not just the report, credit report and score within 30 days. Because if they've already done it, or if they've already paid for one and they have a copy of it, like if they're looking for a unit, then they typically they may have access for it already. So then if they have, then they don't need to buy another one, or I don't need to buy one for them. And so, but again, but within 30 days and report and score. Now, that's in the US. On the Canadian side, the landlord cannot charge for this. And so I have to pay for specifically a credit fee. Criminal record checks and court checks specifically are free, at least in BC and other places. I've checked in other Other locations like Manitoba, free. Mhm. Okay, let's move on. Let's keep going with Maryland pet policy. Landlords must include a written copy or a summary of their pet policy in their rental application form. This is the first time I've seen this actually. This is actually really good. Pets are often negated. Negated. They're often forgotten in tenancy, and quite frankly, a lot of people they have pets. They want to have their pets. Pets are part of the family. I'm a dog person. We are pet friendly. So a pet policy in Maryland must include any breed or weight restrictions, any limit on the number of pets allowed, any required fees, including upfront non-refundable pet fees, refundable pet deposits, monthly pet fees, vaccination requirements, liability insurance requirements, and any additional requirements. The biggest thing that I put in there is the number of the pets allowed and typically the breed. You can talk to your insurance agent if your insurance policy is negated because of certain breeds and it's not, not what you may think, right? Like there's some really nasty breeds that can be really, really harsh. But the trick is that any additional requirements, I have a lease addendum item stating that any aggressive behavior or any behavior of someone else that goes out of their way to change their normal routine, meaning let's say they have there's a tenant with an aggressive animal that's coming up and they don't want to report it, right? They don't want to say anything, but they deliberately, instead of walking past them, they will change their route. They're going to go change their laundry, let's say, and they don't want to encounter this owner with this aggressive animal or this animal that has aggressive behavior. Just the fact that they're changing their normal routine is an alarm for me, right? I don't like that. And so if that's reported, if there's a bite, if there's an attack of any kind, instantly the animal must be gone within 24 hours. Like no negotiating. You can't have them. You cannot have them, right? So a safety issue, no. So that's pet policies. There's a couple different ones you can extract, but that's what I do. They must be on flea medication. They also have to be fixed for us. We're not a puppy breeding. No, so they have to be fixed. And then the number of pets allowed, we go by heartbeats in the unit. So if they're renting a 1 bedroom and they've got 3 people and a kid and 2 dogs, that's not going to work for a 1 bedroom, right? It's too many heartbeats. And so we also just make sure it's size dependent on what it is. Assistance animals. I'm not going to go into this. There's all kinds of information on the assistance animals. They are not a pet. Assistance animals have a job. And I have several episodes coming up where we're talking specifically about emotional support animals, which is sort of this in between. They don't have a job, but they also are helping tenants, but the tenant doesn't have a free pass to have an animal just sort of wreck the place or be noisy, right? So I've got some guests coming up that are going to talk to us more about emotional support animals, which is not an assistant animal. So there's sort of multiple different versions of this. But an assistant animal, a service animal, is pretty well internationally accepted. Canada and US, also Australia, the assistance animals. And yeah. Okay, so we are continuing on. This is the Tenant Bill of Rights for Maryland. Leases and tenancies, it's talking about written lease agreements. A landlord who rents 5 or more units in Maryland is required to use a written lease. This is really important. If you've been listening to the show, you know that if it wasn't written down, it didn't happen. And if you don't have a written lease and it starts to go sideways, it just becomes he said, she said, and then what? And then you try to go and apply at the court and you don't have a lease. So just set yourself up for success moving forward. Have a written lease, regardless of the number of units that you have. Even if you have one, I would still recommend you use a lease. Let's see. Tenancy is presumed to be 1 year from the tenant's first use of the unit. You want to be specific on what it is, condition of the property, explanation of who's paying for what as far as utilities, receipt for the security deposit. You must include the most recent version of the Maryland Tenant Bill of Rights. Tenant's Bill of Rights. Contact information for the landlord or authorized agent. And local jurisdictions may require additional information on the leases, especially if you're listening to this and you are a landlord in Maryland, you really need to make sure that you're very educated on the requirements for your local area, whether it's municipality, your county, whatever it is, because they are very different, which, other states, other locations, even other provinces, it's very widespread, like on the whole area. And in Maryland, it's very, very granular. So you've got to really know your stuff. Okay. So this is the deal breakers. A lease may not include in Maryland anything that requires the landlord to confess judgment. You basically the landlord can't make you agree to be guilty, anything that gives up your legal rights, or provision that shortens any notice period required by law. Basically everything, the law trumps whatever the lease says. So if the lease is wrong, yeah. An automatic renewal term in a lease must be separate from other parts of the lease and signed or acknowledged separately by the tenant. So auto renew in lease must be separate and signed separately. Okay, and then let's talk about ending the tenancy. For your landlord to end tenancy, a written lease with a stated term, landlord must give you at least 60 days written notice before terminating tenancy. For month-to-month periodic tenancies, the landlord must give you at least 60 days written notice. And for year-to-year periodic tenancy, the landlord must give you at least 90 days written notice before the tenancy ends. Year to year. All right. Wow. And then for a tenant to end tenancy, this is probably going to be different. For leases with a stated term, month-to-month tenancies and all other tenancies except year to year, you must give at least 30 days written notice before terminating tenancy, unless the lease gives you more time, unless you've agreed to it in advance. But if it's year to year, you must give at least 90 days written notice. And this is for landlord or the tenant. You both the same thing. Now, this is different. There's actually an asterisk in the tenant bill of rights here. It says this requirement does not apply in Baltimore City, where tenants are only required to provide 30 days notice to end all tenancies. All tenancies, 30 days notice. Okay. Now, there's some nasty stuff that's in every tenancy agreement that's typically about violence. So there's ending your lease early due to abuse, how to do it. I'm just gonna go past it because it's really heartbreaking for me and I've seen it. We've been a part, some of it, had to let people out. If the lease ends and no one gives notice, the lease may automatically renew or become month to month. Less common tenancies like week to week or year to year, or farm tenancies. Farm tenancies have different notice requirements. Okay, rent. Let's talk about paying rent. Rent is due as your lease states, which is for us is on or before midnight on the 1st. If you pay late rent, your landlord can charge a late fee, but it cannot be more than 5% of the late rent amount. You cannot be charged late fee on partial rent payments paid on time. So if your rent is $1,000 and you were only able to pay 500, leaving 500 left, then your late fee would be 5% of the overdue amount, which would be the 500, right? So it'd be $25. Rent increases. Let's see. Your landlord may only increase your rent when your lease is renewed. In most cases, they must tell you in writing 90 days in advance. Some local jurisdictions may limit how much rent can be increased, but there is no statewide law that limits rent increases when your lease is renewed. So that means they can put it up to market rate, basically. It looks like your landlord can provide notice of a rent increase by email, text, utilities. Your utility must, okay, so that was the end of rent increases. So may only increase your rent when your lease is renewed. So it looks like year to year. It's implying that your rent or that your rent can go up when it's renewed. But if you're on like a 6-month lease and then it gets renewed, then it looks like it can be increased again. And then, it gives you landlord can provide notice of rent increase by email, text, or electronic portal only if you have agreed to receive notices electronically. Now, this is key here because a lot of things get missed, especially emails that go to junk files. Make sure that if you are agreeing to this as a landlord, that you've got some other way to confirm that you've served people these rent increases. Yeah, sending emails is not always the best. I still, even today, even if I have their email, I still post it on their door. Okay, utilities. You must offer heat, light, electricity, hot and cold water, proper sewage disposal. Your landlord is not responsible if these utilities are not available because you have not paid your bills that are the tenant responsibility. There you go. If your lease requires you to pay utilities directly to your landlord, your landlord must provide the copy of monthly utility bills, or at the beginning of each lease term, they've got to summarize it. Some landlords in larger buildings use the ratio utility billing system known as RUBS, where tenants are charged a portion of the total building's utility costs. If your landlord uses the RUBS system, they must tell you before you sign your lease if you're going to use the RUBS ratio utility building system, known as RUBS. And then this is a portion of the building. Yeah. Utility costs. Okay. So they basically got to give you a statement. Like if you're a landlord and you use RUBS in like a multifamily unit situation, like multifamily building, you've got to make sure that you are periodically giving statements of what the tenants are either due or paying or both, or how it's calculated, typically with the bills. All right, let's get into security deposits. This is actually really good because it's hitting all the high points on the bingo card. Sometimes we have to hunt and peck on this, but not here. This is good. Well done, Maryland. Okay, maximum deposit. In most cases, a landlord may not require you to pay a security deposit higher than 1 month's rent. You may offer a larger security deposit if your rental application would be denied on credit or rental history. Interesting. Okay. 1 month for a security deposit, you can offer more if denied by credit or rental history. Now, as a landlord hearing this, why would somebody with a rental history want to be offering more credit? Likely, if they have a bad rental history, just that might be a red flag. I'm just saying. Your security deposit may be up to 2 months' rent if you sign your lease before October 2024, or if you qualify from looks like some kind of assistance. Department of Human Services and lease agreement requires you to pay utilities directly to the landlord. Okay, a security deposit. Okay, and then it defines it. This is good. A security deposit is any payment you give the landlord, including pet deposits, to protect the landlord against unpaid rent, damage to the unit, common areas, major appliances, furnishings, damage due to lease violations. Very interesting. Okay, payment rules. Your landlord may not require you to pay more than the sum of the first month's rent and security deposit before you move in, meaning sometimes people try to do first and last and security deposit, meaning you've got a triple threat. Most of the time that's pretty unaffordable. And so this is actually probably a good thing. You don't want to deter a good tenant if they have to pay triple. So typically it says it may not require you first month's rent and security deposit. The landlord must keep your security deposit in an interest-paying bank account and given a written receipt for that, which must be included with the written lease. The landlord must inform you about your rights and landlord responsibilities regarding the security deposit when you pay it. Move out inspection at end of tenancy. Now, it didn't talk about a move in, but it looks like that's coming up. Landlord inspects the unit for damage, may reduce your security deposit. And so if you plan to move out and want to be present during the inspection, the condition inspection, you must send your landlord a certified letter at least 15 days before leaving. So at this point, if you can imagine, you've already given your notice in some way. If it's year to year, it's 90 days notice that you're departing. If it's in Baltimore City, anywhere, it's 30 days notice that you're departing. But then if you want to be present at the inspection, certified letter 15 days before, leaving. The letter should say that you plan to move, share your move out date, include your new address. So typically it would just be one. You would do a certified letter in advance. And then at the end of the tenancy, the landlord must give you a written list of charges deducted, and they must return the rest of your deposit with interest within 45 days. Allow deductions. Charges a landlord may legally deduct your security deposit as property damage beyond normal wear and tear. What is that? It's like sledgehammer to the walls kind of thing, punch marks, doors off, cabinet doors off, things like that, where it's not just a little bit of wear and tear. And typically what I look at and I say, is this going to be fixed within 3 hours of work? And you might say, wow, that's a lot. Well, But if I say 3 hours of work, that's cleaning, that's a handyman, that's just doing 3 hours of work on a unit, that's sort of unless there's malicious damage, that's different. But if it's just dirty or it's a bit worn, that's normal wear and tear. But you're looking for maliciousness, you're looking for stuff that actually has to be physically rebuilt or reassembled. That's not normal wear and tear typically. Okay, unpaid rent or utility bills can also be an allowed deduction, costs or fees. If the deposit is not returned on time, you may sue the landlord for up to 3 times the amount. Wow. Within 45 days. Goodness. Okay, condition of rental units. Every rental property must be fit for human habitation. Okay, reporting a problem, mold specific requirements, repair access. So, okay, let's talk about this because this access defined is on the bingo card. Landlords must provide at least 24 hours of advance notice before entering the tenant's apartment, except in an emergency. You must provide your landlord with access to your property to make repairs. Yeah. So 24 hours. And typically, it doesn't say it, but typically it's got to be, you can't be at like 3 in the morning. It's got to be during normal working hours, right? You've got to at least, it's got to be a reasonable reason, like you're making repairs or you're walking the exterminator or the appraiser or the insurance person through. There's got to be a reason why you're doing it, right? Okay, if the problems are not fixed, meaning there's an issue with the unit, they walk you through on how to report that basic, but you've got to, like, it's a give and take, right? Like the tenant has to give you access so that they can get in and actually try to repair it. Um, mhm. Okay, talking about lead paint, that's a federal thing. If lead paint is present in your unit, there's an issue. If you've got lead paint in your units, landlords, you don't want that. That's not good. Okay, right to quiet enjoyment in the rental unit. Yep. And you have the right to move in and use the unit starting on the date listed in your lease. This can be an issue. This is called delivery of the unit to the tenant. If you've got a renovation going on, or maybe it's a new construction going on, and you've signed a lease, promised delivery of that unit on certain day, and let's say there's been a delay or some weather, or a shipping ship goes sideways in the Suez Canal, and you can't get materials. I mean, this stuff is actual real stuff that happens, and you can't deliver the unit when is promised. Then guess what, landlord? You've got to figure out something else, or you've got to compensate them to live in a hotel or something until the date that they can take the unit, or they can just straight up back out, right? Yeah. This, by the way, that's happened. That's not really fun. Evictions. Your landlord may start the eviction process if you violate your lease, don't pay rent on time, don't move out when your lease ends. So it is a fixed lease. It does end abruptly unless it's automatic renewal. And as we saw in the lease, that if it does automatically renew, you must sign that separately. You've got a court process, walks you through how to do that, how to stop eviction, constructive evictions. Let's see. In Maryland, constructive eviction occurs when the landlord doesn't fix a major issue that stops your use of enjoyment of the rental and you move out instead. Okay, so, okay. When it applies, you may not be responsible for the rent if you can prove all of the following. Your landlord's actions or neglect caused a major issue that disrupted your use or enjoyment of the unit. You told your landlord about the issue, which I would hope you would do in writing, tenant. Make sure this is all in writing. And you gave the landlord a reasonable amount of time to fix it before you moved out, and you moved out within a reasonable time after your landlord failed to fix a major issue. So that's all 4 of those things. Before moving out, you should consult with an attorney. I agree. If you can prove constructive eviction, your lease will be considered ended. You will not be responsible for paying rent after you move out, and you may sue your landlord for losses, including moving costs, rent differences, attorney fees. What landlords must do to avoid constructive eviction. I've never heard that term, constructive eviction. Basically, they either can't or won't fix something. Interesting. I'm just going to do a little screenshot here because I think this is really interesting. Constructive evictions. And there it is. Okay, let me keep going here. Landlords, to avoid a constructive eviction, must avoid substantial interference with the tenant's enjoyment of the rental property, ensure the rental property is safe and livable, generally respond to tenant complaints promptly to avoid legal. Yeah, you basically need to be a good human and run your business properly. And if you're not, then and they take action and move out because of whatever reason, if especially if they're documenting it the whole way, landlord, you need to make sure that you are doing the same thing, that you're being a good, engaged landlord. Or if they're being unreasonable, that you're documenting all that as well. Okay, tenant first right of refusal, and I think that this is means you get the first chance to buy the property you rent before the landlord sells it to someone else. I bet that was what we saw on the website when we first pulled it up. You must be a named tenant on the lease. You have lived in a rental property with 1, 2, or 3 units for at least 6 months, and your landlord plans to sell the property or receives an offer to buy it from a third party. This rule does not apply in certain situations, such as when the landlord transfers the property without selling it. Okay, this is right. What is it? Right of first refusal. Very interesting. I'm enjoying this. This is kind of cool that they've got it. So this is Maryland construction evictions. Okay. Now let's look at the next one, tenant first right of refusal, and walk you through how to do that. That's actually kind of cool. MD right of first refusal. Okay. Got it. Okay, and then just a few more. Prohibited acts by landlords, talking about discrimination. I'm not going to get into it. Oh, retaliation. This is definitely on the bingo card. Landlord may not retaliate, threaten to retaliate against a tenant for making a good faith complaint about a violation of the lease, of the law, or condition of the rental property, filing or participating in a lawsuit involving the landlord, participating in a tenant's organization, requesting police or emergency services at the property, or providing information to the landlord relating to lead paint issues. Retaliation may include actions such as filing or threaten to file a lawsuit against you, threatening to notify law enforcement about your immigration status. What? Okay. Increasing the rent, decreasing the services, and failing to make necessary repairs or terminating your tenancy, filing for eviction, um, amongst other things. Retaliation about immigration status. That is a new one for me. I guess that is part of retaliation, but that's the first time I've actually seen that. Okay, notice requirements before your landlord can enter unit. They defined access above, but here is more. Unless your lease says otherwise, you have the right to quiet enjoyment of your residence. Your landlord has a right to enter your unit for legitimate purposes, such as making necessary repairs, inspections, or showing the unit to prospective renters. They must notify you in writing at least 24 hours in advance of the inspection or repairs. Can only enter unit Monday to Saturday, 7 a.m. to 7 p.m. unless it's an emergency, and you can give your landlord written permission to enter your home with less than 24 hours notice. So you can, if it's more convenient for the tenant, they can allow that. But even working hours, 7 a.m. to 7 p.m., goodness sakes. Um, and then there's a bunch of hyperlinks on this. So if you've got questions, you can actually go directly to the Office of Tenant and Landlord Affairs. There's their phone number and their email. And this is actually really helpful. If you've got a question, like I always ask the question is, can I deny people off the hop because they are a smoker, even if they agree to smoke outside? Sometimes that is a problem in different locations. So if that's a question for you, email them or call them. Maryland Commission on Civil Rights, access to counsel in evictions. This is typically for tenants, but still look at this, legalhelpmd.org. In fact, I'm going to open this up because I don't think I have this in the, let's see, what is this one? Oh, no, legalhelpmd.org. Okay, self-help centers, make sure, and then the People's Law Library of Maryland. Actually, I think I've got that in one of the, yes, and I have this one too. Help centers. In fact, I'm just going to throw this into the show notes right now as we're going. Maryland courts. There it is. District court help centers. Okay. District court centers provide free limited legal services who people are not represented by an attorney. And it says people, meaning tenants and landlords. Landlord tenant cases, small and large claims. So it's not just for housing issues. And then it is very specific to your location. And they're saying court helps law centers will not represent you in court. They are helping you represent yourself. And so depending on where you're located, there is, you can chat. Oh, that's cool. You can chat with them. You can call them. And they've even gotten driving directions where you can pay for parking. No, it says fee parking on the left in all these different locations. This is fantastic. So Frederick, Glen Burnie, Salisbury, Maryland, haha, Baltimore City. Yeah, there's a whole bunch in there. So make sure that if you need help, that is definitely a good thing. There's a bunch of e-services in here, case search, e-recording for land records. You know, you can do all kinds of things, not just for housing stuff, but make sure you're asking questions. But this is definitely that's a gooder. Okay, here's housing cases. And let me make sure I've got all this. So this is the Maryland court help. Okay, we went through this one already. Maryland court help. Did I get this one? Legal help, housing. Yeah, court help. In fact, this is the same one right here. Yeah. Okay, beautiful. Video library, court help, language needs, all the above. Okay, fantastic. And then that's the document we just went through. I just want to make sure that all these great documents that we're finding in these hyperlinks, I capture them all because I don't want to go through it in the video on this podcast and then not have it in the show notes. Like that's not good. So I'm trying to make sure I've got them all. Okay, the next one, Attorney General of Maryland. This is Anthony G. Brown, maryland.gov. And it is talking at the very bottom here, landlord tenant disputes. You can click on this and it actually walks you through how to do this. And it's a lot of leases, application fees. I mean, it's almost verbatim of what we just went through. Rent receipts. Landlords must provide receipts for cash payments upon request. Just a little note here, depending on the location, you might check, but I always give people 3 ways to pay rent. Typically, there is an auto debit function, which sometimes, depending on if you're in Canada or in the States, an auto debit or an electronic method of payment, or I always give them a way they can physically walk into a bank somewhere with their cash and pay their rent and they get the receipt. And so I will do that specifically. I don't collect rents. We don't walk around and collect rents. We put it on the tenant responsibility to pay their rent. This is their bill. And so it says landlords must provide receipts for cash payments. Guess what? They get their receipt right there, right? Okay, security deposits, limits and requirements. We've already talked about this. Must put deposit in an escrow account or interest-bearing account. Interest rates, leases before 2015, 3% per year. Leases after is 1.5%, or the daily US Treasury yield rate, whichever is greater. Inspections, return of deposit. Yeah, landlord may be liable to the tenant for 3 times the withheld amount plus reasonable attorney's fees if the deposit is not returned within 45 days. Wow. So they do accept surety bonds. Premium paid is not refundable. Tenant still remains responsible for damages. Yep, so you can use a surety bond. It's interesting. Maryland is really, really technical in all this. Lease renewals, we've talked about this already. Breaking a lease, tenants remain responsible for the rent through the end of the lease term. That's called an acceleration clause, meaning if you're a year in, you've got a year lease and they're 9 months in and they're going to terminate the lease for whatever, unless it's like military orders. That's sort of the one-off. Then you have to let them out of the lease. But if they're breaking the lease, then they're still responsible for the remainder of the lease amount for the last 3 months. Landlord must make reasonable effort to re-rent the unit. Tenant is responsible to rent the unit until a new tenant moves in, and you may be charged for advertising costs. Yeah. Yeah, so here it is. Military personnel with permanent change of station orders can end lease with proper notice. You still got to do that. Yeah. And here's an interesting one. Persons with medical conditions preventing them from occupying the unit can end lease early with proper notice. Now, this is, we know the the population is aging, right? And so people who are aging and they're starting to fail, if they're not physically able to live in the unit anymore and they're in a fixed lease situation, then be a good human. You realize that if someone has a fall, they break a hip, or they're having trouble walking and they're up a flight of stairs, like, come on now. You got to let them out of their lease. Like, be a good human. Jeez. Okay. Rent, repairs, and escrows. So this whole thing that I'm looking at, wow, this is good. This is good. Okay, this is the Attorney General of Maryland official website. Okay, now one thing we have not talked about yet is abandoned items in Maryland. Now, I did not find the whole state, but I did find Baltimore City, People's Law Library of Maryland. So if you have a tenant abandonment situation, you're not in Baltimore City, you're not sure what to do, go back to either maryland.gov or the district court help centers and explain what the situation is, or get on chat or email them and just say, I have the situation, what do I do? They will help you, right? Like, they will give you guidance. They will give you the source document, which is what I'm trying to do, trying to give you the source document. So, but for Baltimore City law, disposal of tenants' possessions. So when a landlord files an eviction case, they're asking the court to issue an order that authorizes them to regain possession of the property from a tenant who has violated lease terms or has failed to pay rent. Remember, the goal of an eviction is an empty unit. That's the goal, not your money. The goal is possession of the unit. The court order is known as a warrant of restitution. The warrant gives the landlord the legal right to have law enforcement officials remove the tenant from the property to regain possession. However, at the time of execution of the warrant of restitution, any property of the tenant that the tenant leaves is considered abandoned and may be disposed of by the landlord. Abandoned property removed from a property under warrant of restitution is known as eviction chattels. And there is a hyperlink for more on that. I'm not going to go into this because it's quite specific and we knew this. Ooh, ask a law librarian. That's good. And then, oh, here's one, Court Help Center. This is fantastic. And this is exactly what I was saying, is that they've got help places all over the place. So make sure you're looking at this. But let's go back to abandonment. When a court issues a judgment in favor of the landlord, they must provide notice to the tenant, all the details here, and then indicate final notice of the eviction, even if the sheriff or the court postpones the eviction date. To fulfill the notice of the requirement, the landlord must serve them properly, mail a copy of the notice to the tenant, both by certified mail and first-class mail with certificate of mailing, must be at least 14 days, and post a copy of the notice on the premises. Again, all the days in this all matters, right? You've got to make sure you're counting your days. Delay of eviction, even if proper notice is not given. Delay of eviction if proper notice is not given. Yeah. Disposal of tenant's possessions. Okay, so this is Baltimore City. This is not the whole state. There's a whole other different ones. Here's Baltimore County rental and housing laws. There's a bunch more. Prince George's County housing code laws. So all this, I'm on the peoples-law.org Baltimore City link in the hyperlink in the show notes. So there's a ton in here, legal resources for renters in Baltimore City. There's a bunch in here that, depending on where you are, you've got to make sure you are educating yourself, right? Okay, we'll keep going. We're going to wrap this up here soon. All right, the landlord must dispose of abandoned property by one of the following methods: transporting them to a licensed landfill or solid waste facility, donating them to charity, or some other legal means. And here's what's interesting is that if they're evicted, if a tenant in Baltimore City is evicted, at the time of eviction, all of their personal possessions are deemed abandoned. Like, that's it. And truth be told, the tenant is getting notices this whole time that this is coming. And so it's not without proper notice to them saying, this eviction is coming, you need to move your things. And if they don't, then it's abandoned. In other locations, you have to try to get a hold of the tenant and you have to let them know that you have their possessions and then store them and blah, blah, blah. And in Baltimore City, it's eviction, warrant of restitution, you get possession of the unit, and that's it. So interesting. All right, let me keep going on some of these other hyperlinks for you, and then we'll get into the punch list. This is Maryland Legal Aid, mdlab.org, Get Help Services. So here is a bunch of information for you. and frequently asked questions, dispute with your landlord. I mean, and I'm just going to scroll down to the very bottom. Whoop, because they typically have a phone number. Here it is, courts, help centers. We've already talked about this. There's a 410 telephone number, a live chat, and legal aid. And it's not just for housing stuff, right? Yeah, let's keep going. All right, this one is Maryland Multi-Housing Association, Inc., mmhaonline.org. I throw this in because typically there is a organized group somewhere per state or territory or province, whatever it is, for landlords, right? And so I try to throw in other groups, like if you are interested, these guys have courses coming up, which is kind of cool. Now, this is electrical and plumbing. Viewful calendar. Let's see what it is. Driving results through goals. Some of this isn't just landlording stuff. Leasing professional, money mindset for leasing. So it looks like it's also for like professional property managers as well. Lunch and learn. These are cool. Fair housing. I would definitely go to that one. And let's see. Apartment turnover. Like this is the kind of stuff where it's like it's a one-day thing. It may be in person. Let's see details. Is it in person? Is it on Zoom? It looks like it's in person. 8 seats remaining, July 2nd. Here's what you're going to learn. And I'm betting there's a cost to it. It doesn't say what it is. Let's just say register now. Let's see how much it costs. So yeah, so it's a non-member. It's $150 for training all day. It's like 8 hours of training. Plus, guess who's else going to be in the room? That's the other thing, is that the value isn't just in what you're going to learn, it's who you're going to talk to, who you're going to connect with. And that's the whole idea of why I include this kind of stuff in the show notes, right? Okay, so that's one group. Now there is another one here on Facebook, Association of Maryland Landlords, just under 1,000 members. Now it is a private group, but when I just Googled Maryland Landlord Association, this is what popped up. And so again, you want to learn a little bit more about what Maryland landlords are talking about. Join this kind of group if that's what you're looking for. Okay, I also look for renter associations. Just so you're aware, I am a member of the Maui Tenants Association because why? Because I want to know what tenants are talking about, and I want to understand if there's any legislation coming up that might impact tenancy at all. Guess who's probably going to find out first? The tenants, right? Not the landlords. So that's why I joined tenant groups as well. So this one is rentersunitedmaryland.org, and it's got all kinds of updated. So this is all legislation. In the news, there's a summit, Maryland Housing Justice Summit. Interesting. Okay, so there you go. I don't know if you're interested in that, how it is, news and updates, all of the above. Okay, and then last one, Maryland State Bar Association. Now this is typically where the lawyers are. And I always throw this in just in case you need legal help. You may not need to hire a lawyer, you certainly can, but if you just need a little bit of guidance outside what the court can help you do or legal aid can help you do, you might consider hiring an attorney. Even for a consultation, it might cost you $100, but just as a guidance, right? And so they have all kinds of events coming up. Let's see. Yeah, attorneys, things like that. So anyway, I throw this stuff in just because I want to make sure that you have all the tools you possibly can have. Okay, I'm going to put this back here, and then I'm going to go through the bingo card. Anything that we didn't talk about. Okay, let's just rattle it off. Tenant application fee, we talked about this, generally capped at $25. Grace period, there is no statewide grace period for rent. Rent is late the day after the lease date due unless local law grants a grace period. Some jurisdictions, including Montgomery County, Baltimore City, require 10 days before a late fee can be charged. So again, make sure you are doing your own homework based on where your rentals are. Late fee amount, state law prohibits late fees on the residential rent, no more than 5% of the rent amount due for monthly tenancies. And security method, security deposits are capped at no more than 2 months rent, but typically business practices are 1 month. The landlord must provide a receipt and required disclosures. You can use, let's see, wait a minute. Maryland treats the security deposit as separate from rent. It's both in money, but they're not the same thing. Tenants cannot simply designate the deposit as the last month's rent unless the landlord expressly agrees in writing. We've talked about the return of deposit and timing and the violation. It's 45 days, and if the landlord doesn't return it with justification, it's 3 times the amount plus attorney's fee. You can use, in lieu of money for a security deposit, you can use a bond in lieu of deposit system. It's not commonly provided by statewide law, but some places do. If you're a Maryland landlord, reach out to me, especially if you've seen a bond used. That's kind of different. Yeah. It talks about lease wording, but does not provide any pre-made forms or wording of any like warning letters. I didn't see any templates for forms at all. I'm sure the court has forms, but that's different. Just operating as a landlord, there's no pre-made forms or templates. Condition inspection at move-in, you want to make sure that the condition inspection is noted. Now it's talking about the landlord must give the notice of the tenant's right to be present at the initial inspection and at the move-out inspection, and to receive a written list of existing damages and at move-out as well. Standard warning letters or wording, it does not include any pre-made forms or letters. Does not include maintenance inspections. However, there is a lot in Maryland that talks about habitability. And so you've got to make sure that you are doing your inspections accordingly. It doesn't say specifically that you've got to do that, but to keep a habitable unit, you've got to be in there once a quarter, maybe even every 6 months. We're typically in our units every 6 months, sometimes faster than that, depending on what's needed. Emergency contact required in case of abandonment, incapacitation, death, or imprisonment. Typically, it looks like Maryland statewide landlord tenant statutes do not clearly mandate that there is an emergency contact. However, best practices have a next of kin. Statewide Maryland law does not prohibit pet deposits or monthly rent. But if you're going to charge a pet deposit, it can't be, according with the security deposit, can't be more than 2 months charged for deposit. And obviously, this is not for service animals, right? It's got to be and clearly stated in the lease. Maryland does not specifically require renter's insurance. Abusive access is defined. We talked about landlords providing proper notice, days of the week that they can go in, hours that they can enter, reasons they can enter. If that is not specifically spelled out, it says abusive access is defined in the statewide code. We didn't go into that. That's fine. Okay, there is definition of landlord retaliation. In fact, I'm kind of shocked that they talked about the landlord retaliating by threatening to turn them into immigration. That's new. I've not seen that before. How often can rent be increased? Maryland has no statewide rent control schedule limiting how often the rent can be increased, but increases are governed by the lease term and local rent stabilization ordinances. So again, one more time, make sure you are checking out your local laws, because they are going to be very specific based on where you're operating. Retaliatory and discriminatory increases are prohibited. And we talked about end of fixed lease, acceleration clause, yes. And we go to court. We talked about abandoned items. And I think we've got this. I think we've got everything that we were going to wrap it up. So let me come to a close here. Each of my location-specific podcasts is set up in the exact same way, answering the same 4 questions. What are the basics of that location's governing document regarding tenancy, residential tenancy? What are the nuances of that location? What's some guidance about abandoned items left behind by a tenant in that location? And then finally, where to get help in that location. As I did that, you saw me keep track on my bingo card of standard items I see most in tenancy laws in different locations worldwide. And then I summarize that at the very end of the episode. And this is the same format for every location specific episode I do. So if you're interested in another geographic area, or you're interested in just seeing some of the other crazy places I have, like in this tranche is Tasmania, Australia. They do this totally different. It's actually kind of cool. So check it out. This episode, one more time, is not all inclusive. You must further do your own research in the specific area, especially right where your rentals are. The whole idea here is that this is not designed to be all inclusive, but it will get you started. If you're listening to this podcast, chances are that you're either new to real estate in Maryland or you want to be in real estate in Maryland. Things you can do to help yourself are make sure you know the rules of the game, again, specifically where you're located. And the other thing you can do is get in the room with the other Maryland landlords, either physically in the room by way of a meetup or a training course or something, or get on social media and join the conversation on virtually with other Maryland landlords. Learn from them. They've already done it. So make sure that you are checking out everything else in the show notes. This is actually really cool that you're um, learning more about this. This is ideal. And as we go through here, I want to make sure that you know that we've got over 200 episodes in the My Life as a Landlord library. Make sure you are doing your homework, but also check out, there's probably other episodes that might help you or might help someone that you know. Don't forget to subscribe to My Life as a Landlord for more expert advice and real stories from around the world. I'm recording this episode today in Maui, Hawaii. Why? Because real estate takes you places, and I'm crazy enough to run all over the world and record podcasts. Where do you want real estate to take you? Join me in the next episode for next week, which is episode 226, where I talk about the inevitability of tenants passing away in your unit. I interview Hospice Maui's Tanya Barbero. I'll see you there.